Good evening, everyone. We're going to call the meeting of the Board of Appeals to order at 5:30 p.m. Present, we have Michael Polson, Cara Espera, and Wendy Smith, who's the chair. The meeting has been properly noticed and posted according to law. And now I will turn it over to Chair Smith.
Good evening. This is the meeting of the Board of Appeals. Our agenda packet has been distributed prior to this meeting. In accordance with the agenda packet, we'll go in order, beginning with item number 4, which is consideration of our prior meeting minutes for our meeting on January 9th, 2024. Any member of the board that has suggested corrections? Hearing none, these minutes are approved. Moving forward, we have one item for review this evening. And in preparation for hearing that item, we'd like to ask our village attorney who is present at today's meeting to review the standards by which the board shall abide in consideration of item number 6, which is listed as a request to appeal interpretation of Village Code 225-8B sub 5. With that, I'll ask our village attorney to provide us with the standard for our review.
Thank you very much. So because this particular application or appeal is a little different than the normal appeal that the Board of Appeals has addressed in recent history, I think it probably starts, it's probably good to start with sort of a 30,000-foot view of what we're looking at and what we're talking about. And then I also, before we move into that, I have a clarification question to ask to the appellant as to whether this is a appeal of an interpretation of the code or whether it's a request for a variance. So the appellant tonight is Mr. Schwab. Is that correct? I apologize. And then his contractor is Landworks Inc. Is there any clear thing from the contractor? Did you want us to wait? Is there any coming? No. Okay. So the property in question is over on Richland Court. It's 4039. So there was an original building permit application submitted in September of 2023. And it was for a three trellis section, essentially 8 feet in height. There was also some other portions of the permit that related to fencing and a gate, but those are really not an issue here. So where this saga begins is it was originally approved by the permit application, which was 2013-1588. And again, you'll hear testimony later from Mr. Boris from the city inspector's office, but just again, 30,000-foot view, the village acknowledges that essentially the initial permit was issued in error. And the way that this came to light, as I understand from reading the materials, is essentially the neighboring lot is a non-conforming lot such that when these trellises were installed, they were essentially flush against the neighbor's property. And I think the photos you can see that are attached, the color photos at the end, that basically show the trellises almost right up against the neighboring property, almost touching or right under the roof in some cases here, is a good graphic view of that. So they were somehow, there was concern raised. So they went out there, they took another look at it. And then they issued a notice of correction on October 2nd of 2023 with a couple of options. One was to lower the height of the trellises to 4 feet, and that would essentially be interpreted as a fence, or to move further off the lot line to meet the setback requirements, and those are laid out in the corrective order. So again, the original permit application was in September. It was initially approved, and that is a notice of correction was issued in early October, while before as I understand it, before all of the trellises were had been erected or installed. So the first question I would have is when we look at the appeal, there's a couple of different boxes that can be checked, and one which is a request for a variance is the one that this body handles certainly a lot of times, very often. But the other one that was marked in this case was appeal to interpretation to allow. So I want to explain what that is. That is basically saying we are challenging the way that the inspector's office, the village inspector's office, applied the code. So in other words, we think that they miscalculated the, the amount of feet, for the setback, or we think that it's technically not a fence, or whatever it might be. That's saying, we think that the code was misapplied and we are correct. But when I look at the application, I do see that all of the areas that list the criteria for a variance, those areas were filled out. And that is consistent with, the criteria as laid out in the village code, Article 10 of 535 zoning, which lists all the Board of Appeals, jurisdictional requirements and also lists the criteria for variance. So I guess at this point, before I determine what the final criteria would be, I would ask the applicant whether they're saying that we believe that the code was misinterpreted and misapplied, or whether this is request for variance. Why don't you go on up to the
Maybe I don't understand the question.
Sure. So there's the jurisdiction of the Board of Appeals is such that they can do a couple of different things. I'll just give you a concrete example. Let's say that they issue a corrective order saying that someone has to be, 3 feet off of a property line for the setback. And there's a special exception that relates to non-conforming properties. There's some of a special exception. And the individual might be saying, I qualify for the special exception, so I don't believe that the code as written, the 3-foot setback applies to me. So that would be a dispute as to how the code is applied and whether the inspector's office correctly applied the code. The other jurisdiction that the Board of Appeals has is someone can come in and say, I understand the code was applied properly. And it's true that in a technical sense, if we applied the code here, that I would be required to follow that with respect to the setback or whatever it is. However, I'm asking for a special variance because there's something unusual about my property. That a literal enforcement of the code would create an unpractical hardship or an unnecessary hardship or a practical difficulty. And even though I don't comport with the code, you should grant me this variance because of the unique circumstances that are associated with my property. And the application actually has portions of the application that address unnecessary hardship and practical difficulty and all of those things. And I saw those filled out under application. So I wasn't sure. I thought one of two things, because I don't want to put words in your mouth. You may have inadvertently checked the wrong box and you're asking for a variance, or I'm misreading your application and you are saying that they misapplied the code, and I wasn't sure which one of those it was. Does that help?
I think that actually in this situation, this application process is confusing. I don't think that there is a clear definition based on that. I don't know if now's the time we need to correct you. You made a couple of statements that actually aren't true.
If we're going to get into the factual record, he hasn't been sworn in yet.
Okay, all right. So I think that there's understanding how to fill that out. I agree. It was confusing based on the situation that we're dealing with, based on the situation that the work was approved. The work was 70% substantially completed, not to correct sort of a statement that you made. The foundational work was all done by the time the village came back out and put in their correctional order. So I don't know exactly how to answer that in this situation, because the work was already done.
Okay,
So that's what, so if there's guidance that you can provide,
well,
that's fine, but it wasn't like you guys came out and issued a corrective order prior to the work being started, because that's not the case. It's not like the work was done around the bounds of the village ordinance, because that it was when it was submitted. So I don't know actually how to answer that.
Okay, so let me just back up, and again, I
recommendation.
usually tried to give a sort of a 30,000 foot view, if you will, of what I think some of the issues that will be discussed tonight. I'm in no way, in any shape or form, putting in any evidence in front of the body as part of the record. So I apologize if I said something that you disagree with factually. That wasn't my intention. My intention was to just sort of lay out what I think we're gonna be hearing tonight, so we can try to ascertain as to whether or not you're saying you believe the code was improperly applied, or you're requesting the variance. As I can't give you any, I can't make a suggestion to you or give you legal advice as to how to plead your case, because my role is to try to tell this body here, the Board of Appeals, how to approach it. The way I read it, and I guess this would be, my interpretation of it, is that when you look at the application itself, the sections addressing practical difficulty, unnecessary hardship, and other elements that would constitute a variance, there are, there's written material there, there's responses to all of those. And personally, I did not see any particular, focus on a particular code item that was misinterpreted or misapplied. So I read it as a variance request. But again, I didn't want to presume, so I wanted to allow the applicant or the appellant to say, no, I believe that, they misapplied 326.1 relating to fences, or 535.6 the relating to structures. If that's the argument you wanted to make, I did not want to presume to make that interpretation on your behalf.
Once again, I think that there's some very significant semantic issues here, because the village ordinance around what is a trellis, and more importantly, what isn't, is vague. The issue around, am I dealing with seeking a variance versus a misinterpretation of the code, is based on the situation that we're dealing with here. So for me to answer that without, sort of potentially putting the situation in any sort of like legal semantic jeopardy, I don't know how to answer that based on the situation that we're dealing with, if that makes sense from my perspective. And I don't know
Sure.
if we need to talk about it further, and or open up sort of evidentiary
Well,
sort of part of it, but I don't know how to.
sure. So so I can only give advice to the body. So here's what I would say. To the extent that during today's hearing, the applicant raises an issue that the code was misinterpreted or misapplied, then, the body can analyze that on basically what we would refer to as the no review. They can take a fresh look and see, okay, what does 326.1 say about fences? What does 536.6 say about structures or accessories? Or, along the lines of along those lines. However, to the extent that, that you, see this as a request for a variance, as we know under 535.58, there has to be exceptional circumstances found and an absence of detriment before a body can grant a variance. And the variance essentially presumes that I'm not meeting the applicable code. However, there are special circumstances associated with my property, and there's an absence of detriment if you allow this to me, and the exception will not swallow the rule. And then I would analyze it as you would analyze any other variance. So I think we'll have to adapt on the fly here, depending on what we hear from the appellant. So, I guess what I would recommend is to swear in the inspector, Mr. Horace, hear his explanation of it, hear the explanation, and swear in the appellant, and take any evidence from each of them. And then we could have a discussion. The first question that could be raised by the chair is, has there been any direct challenge to the application of the code? And if there is not, then there's no reason to have a discussion of that. And then the second question would be, is there any request for a variance here? And I think at the very least, I would interpret the application submitted by the appellant as a request for a variance. And I would analyze it pursuant to 535.58. and determine whether you can make a finding of exceptional circumstance and absence or detriment, and then have your normal analysis. That would be my recommendation.
Thank you. Questions for the village attorney from board members at this time?
I think that's a reasonable.
Yeah, maybe
Okay, we'll
figure it out.
figure it out.
And I apologize for that long explanation of the questions, but I did not want in any way to presume what you were trying to tell us through your application, so I thought it was important to ask those questions. Share that.
Okay, so then moving on, we will move to consideration of item number 6, which is request, and feel free to sit down for the meeting. Request to, this is phrased as request to appeal interpretation of Village Code 225-8 B sub 5 to allow installation of 3 trellis sections at residential property 4039 North Richland Court, and as stated by the village attorney. We will be considerate of the various issues that may come up as we discuss this. So how this will work is first I will ask for a statement from the village inspector. Once we've had the opportunity to ask questions of the village inspector, we'll proceed to statements that could be made by the applicant. Also statements that may be made by members of the public that have interest in this matter. Moving forward. Hoya, can you swear in Inspector Burris for a statement?
Yes, can you raise your right hand? Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
So as Nathan stated, I'll repeat some of what he said there. So again, our Department of Planning and Development reviewed and approved a building permit application on September 20th for the construction of 3 trellis sections 8 feet in height along the southern property line in a section of fencing, including a gate and residential property 4039 North Richland Court. At the time of the initial review, the interpretation was that the trellis panels were separate and distinct from the fence, and therefore may exceed the maximum height requirement of a fence that is otherwise limited to a height of not more than 6 feet. When a fence runs parallel to a primary or neighboring residence, and that fence is within 6 feet of either property, the height of a fence is actually limited to 4 feet in height. The location of the trellis panels in relation to the property line and the neighboring home was not adequately considered through the initial review. On October 2nd, the village was contacted by the neighboring property owner at 4033 North Richland Court, questioning the location and height of the structures that were going up. A subsequent inspection was conducted, and it was at that time it was understood that a mistake had been made. So that same day, a correction notice was issued to the property owner and the contractor to modify the height of the panels to that lower section of 4 feet to comply with the fence requirements. At the time of that initial site visit, 4 of the 6 6x6 members were set in ground, but the trellis panels were not complete. Given that the trellis panels are located within the side setback on the lot line, they should have either been denied for being located within the setback, incorporated into the fence and reduced to 4 feet in height, or required to be relocated at least 3 feet from the property line in accordance with accessory structures for general setback requirements. Within the packet, we have the definition of fence. We have the definition of accessory structure. The village does not have a definition of trellis. Again, at the time of the initial review, there have been very limited number, but a few other times where, say, again, we have other things, an arbor or a trellis where they've been installed. And so we have made the interpretation of these not being fence panels. So again, we have the 2258B the section that details fences and that, no fence more than 4 feet in height may be erected between adjoining properties when the fence parallels an existing residence. Again, these properties are located in the R6 zoning district where the interior side setback would have otherwise been 3 feet. The position of the village now is that the trellis panels shall either be considered fencing, requiring the panels to be lowered to a height not exceeding 4 feet, or that the panels be relocated 3 feet from the lot line to comply with the setback requirements for accessory structures. And then again, within the packet, we have a number of photographs, the original building permit application and plans that were submitted, notice of correction, the Board of Appeals applications, number of maps.
Thank you. We'll open this up for questioning from members for Inspector Burris.
I just have a clarification on the options to remedy the issue here. So one was like just denied the application again. The second one, it says incorporated into the fence and reduced to 4 feet in height. So that means like they would not be three freestanding trellises anymore. They would have to be connected.
No, I'm sorry, yeah, they would not have to be connected, but that they ought to be considered fence panels and not trellis panels, and then lowered to 4 feet in height.
Okay, so it's just the reduction in height.
Yeah.
Okay.
So you're saying it wouldn't have to be connected to
No,
the
yeah,
gate
correct.
fencing area?
Right.
So it seems confusing to me as to whether a panel like this, a trellis panel, whether it's 4 feet high or 8 feet high, whether it can be both a fence and an accessory structure at the same time.
Mhm.
And so, at least from the notice of corrections, it appears that the village is taking the stance that it's fencing.
Yes,
But now we're hearing multiple options for whether it's a fence or an accessory structure. So does the village have an interpretation of what this is?
sure, so.
Because it can't be both.
Right, so, and well, this is, so that, yes. And again, that is why, upon the initial site visit, it was apparent and isn't, maybe is in those photos. When you see how close these panels are, in the spirit of the other parts of the code, in spirit of the fence section that says, when you have a fence that is within 6 feet of your neighbor's house, it can be no more than 4 feet in height. We look at this and go, okay, so maybe these are not, it is not traditionally a fence, but in the spirit of the fence section, they ought to be considered fence panels and limited to 4 feet in height. If the applicant wants to maintain that this is not fencing, then it is a trellis, then we would say it's an accessory structure and has to meet the setback requirements. Fences do not have to meet the setback requirements. They are specifically omitted from that in that chapter.
So if it's considered a fence, it needs to be lowered. If it's considered an accessory structure, it needs to be moved back.
Correct.
But it could be left at 8 feet at that.
Yeah.
So it's either leave it at 8 feet, but move it off the neighbor's wall, or cut it down to 4 feet and leave it
Where it is.
physically where it is. Is that right?
Correct.
Okay.
So do you have a sample example of what a accessory structure is?
I have the definition. It is in
I see the definition. I suppose
typical.
you said that you don't typically have trellis panels like this come up.
Correct, yeah.
So what would accessory structures typically be considered?
Sheds.
Sheds.
Yeah.
So there is the definition of accessory structure, a structure subordinate to the principal building located on the same lot or parcel, serving a purpose customarily incidental to the principal building.
Correct.
Okay.
And so structure is anything that is placed affixed to the ground. Essentially, you stick a flag in your yard, it's a structure. And, yeah, the very broad definition.
So I think you just said a flagpole would be
Yes.
considered a structure. And it would be required to be at least 3 foot back. And then would have a limitation of, I think it's 15 feet you said for a
Correct.
structure.
Yes,
So, it does not need to be a building. It can be,
correct. Little free libraries are structures, retaining walls.
clothes rack or,
Yeah, I suppose my question there is it the board's, is the board looking for a definitive answer as to whether the village interprets this structure as an accessory structure or as a fence?
And to say to the applicant's point of say this being somewhat of a, well, completely untraditional scenario, because we don't have a definition of that. So I'll say that if he were appealing our interpretation, we are now taking the stance that these are fence panels. And therefore need, because of their location, we're going to say that they're fence panels and that they need to be limited to a height not exceeding 4 feet.
And the village attorney, is that sufficient for us to ignore the possibility that these are accessory structures? If the village is asserting here that their interpretation is that this is a fence panel.
And correct me if I'm wrong, what I hear the position of the village being, and I think this is appropriate under the way I read the code, is that if it's 4 feet high, it can be that close to the lot line. If it goes above 4 feet, then it has to be moved off the lot line because it exceeds the height of the fence, and then it can be evaluated as an accessory structure if it's moved further.
That is correct, yes.
Does that make sense? So it's, what it is dependent on the height.
Yes, so if the current structure exceeds 4 feet in height, and the interpretation that these are fence panels, then in terms of what decision we need to make as a board, I suppose, are we authorized to offer kind of contingency plans?
Well, yeah, I think you can, because
which is what the village.
as I understand that was, why don't you explain it? That was the,
Yes, again,
Yeah, I understand the two alternatives. I guess I'm just having difficulty understanding how one thing can be two separately defined
sure. So
under the code.
a fence is a structure. A fence technically is an accessory structure, but fences specifically are omitted from meeting the setback requirements.
Okay, so the interpretation of a fence is that it is an accessory structure.
It is, yes, yes.
Okay, that helps. Okay,
it's sort of determined by location and height. If it's within so many feet of because the fence can go all the way up to the lot line as long as it's 4 feet or below, right?
Correct.
So if it's, and that's the issue here. And frankly, I mean, to be fair to everybody, part of the issue here is that the neighboring property, because these houses were built before the advent of the code, that if the house had been built after the advent of the code, the house wouldn't be all the way up to the lot line like that. So nobody probably would have ever noticed. Nobody would have gotten their, feathers in a ruffle about it, and we just got built and nobody did. But when they're reviewing, as I understand it, when you're reviewing the application, you don't necessarily know that you realize that the neighboring lot is has an unconformed or an unconformed structure on it, which is the house. That's right up to the lot line. It's an allowable non-conforming structure because it was built before the code.
Correct.
So in other words, when these went up, you didn't realize it was gonna be jammed right up next to the neighboring house.
That's correct.
I mean, I think that's really the issue. Otherwise, if there was another 3 feet on the other side of the lot line before you hit the house, we probably wouldn't be here. I mean, that's, you know, it would technically, but if it's gonna be on the lot line, I think the way to look at it is if it's gonna be on the lot line, it technically can't be any greater than 4 feet. And if you want to maintain 8 feet as an accessory structure, then you gotta move it off the lot line.
That is correct.
While we're on that point, perhaps Inspector Burris, can you comment as to or confirm that the neighboring house, I believe it's on the southern
Yes.
border, is of the category of legal nonconforming? Because there was some,
It is
Please.
legal non-conforming, yes.
and for the purposes of the audience, what does legal nonconforming mean?
So legal non-conforming means that the house was constructed prior to the adoption of our current zoning code. Current zoning code would require a minimum 3-foot setback of the house from the lot line, and the current house is on average less than 2 feet from the lot line.
Okay. Other questions for Inspector Burris before we move on? Hearing none. I'd like to invite our applicant up to the microphone if you'd like to make a statement. Toya will swear you in.
Can you raise your right hand, please? Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So help you God?
I do.
Thank you.
And can you please and say your name and address into the microphone for the record?
Schwebel, SCHWEBEL, homeowner, 4039 North Richland Court.
Thank you, Mr. Schweibel. Feel free to make a statement as you wish, addressing any of the issues we've already discussed or in your application.
Yeah, I think all of my comments on the application are part of the official records, right? So, you know, just a couple of things to reiterate here. We're not talking about what definitions are, interpretations are or not. We're talking about the fact that I submitted a fully detailed and comprehensive landscape plan that correctly labeled everything that was within consideration for code village compliance. Within that compliance was the definition and or your lack of, which you on display, created your own potential jeopardy around what is a fence, what is not a fence, what is a trellis, what isn't a trellis. Under your current published guidelines of what is a trellis, my structures, which are not a fence, comply. Post that, the work, the foundational work was almost 100% complete. When the Inspector Burris says the trellis work, meaning the lattice work, which is, by the way, 50% opaque, the foundational elements of the 8-foot high structures of the trellises were already put in place and done. More important portion is that the landscape plan was predicated on those being trellises. I didn't run a row of arborvitae down the house. I didn't run a fence down the house because I didn't want to run a fence down the house. I wanted trellises. The trellises were designed in the plan per your code language. The interpretation or the post-situation interpretation of what you don't have defined is not my burden to bear. We are talking about inflicting significant punitive damages by the after the fact interpretation. The issue for the board here is to correct the vagueness of the situation going forward, because I did not do anything in the spirit of or intentionally around what the code and language was. I designed a plan, and the plan was specifically around those 3 trellises. That's what we're debating. And this is like in a very similar situation, approving the foundational plan for a house, having somebody's personal opinion weigh in on the public record and impacting the foundation of the house and having to redo it after it's already laid. That's not the moment we're in right now. The moment for you now is to say there was a vagueness apparently in the code, in the definition of what is a trellis and what isn't. I will challenge you on that being considered a fence. Because if I was here in front of you saying, I'm putting in a pool, I've got my fence. Or more importantly, a fence in the defining area. If I had a dog, will those trellises prevent the dog from going on my neighbor's property? No, they will not, because they are not a fence. They are a trellis designed within the code as published. And more importantly, all of this is retroactive infliction of a reinterpretation of a vague code by the village, incited by a private citizen that creates a cohort. That's very dangerous jeopardy for the village to be in. I didn't do anything against the code. I didn't create any sleight of hand. I labeled everything by the most respected contractor in this region who reviewed the plans. They stamp them, they put their confidence in them because they meet the letter of the code. That's not the situation we're in now. I will also tell you, in the spirit of being a good neighbor, I could have run, because you do not have language in your code, I could have done more offensive and oppressive. I could have run a row of arborvitae down the entire lot line of the existing non-conforming house, obstructing all light, making it impossible, because you do not have language in your code that prevents me from doing that in the lot line to make it impossible for them to access their house. The trellises aren't in a position where they prohibit any access to the roof, to the masonry. They are on the lot line, they're actually right inside the lot line. I think that needs to be clear in the order, because it was insinuated that they were either on his property or their property, and or that they're right on the lot. They're not right on the lot line, they're actually right inside of it. But the issue here is not about what my situation is. The issue here is about the vagueness of the village's code and the selective retroactive reinforcement of the vagueness of that code based on the spirit of what I built, what was designed, and the workmanship with which I pursued. Anything beyond that, that creates an entirely new potential system of jeopardy.
If you don't have further statement, I can't open this up for questions from the board at this time. Does anyone have a question? And Mike, try to go talking to the microphone for the record.
Not used to being in the courtroom. Mr. Schwedel, where is the definition of trellis in the code that you are relying on to say that it was forbidden?
I think Inspector Burris illustrated what was the definition of a trellis. I'm not going to try to recite it from memory. What you have, more importantly, and I'm sorry, I don't know your name. More importantly, the definition of trellis for the sake of the village is potentially vague. And the definition of what I built, and Justin Burris, or Inspector Burris, he can recite what is the definition of a trellis by village code if you want that in there. But the acceptable definition and requirements are up to how tall. I don't know what that, that's basically what I've built.
So is there a definition for trellis?
No, that was part of the issue, is that the village has a definition for a fence, which is a barrier enclosing or bordering a field yard, etc., usually made of posts and wood used to prevent entrance, to confine, or to mark a boundary. The village code does not have a definition for trellis.
So anything that doesn't have a definition within the code would just de facto become.
Trellis is mentioned in your code. Is it?
But
not?
It is not.
So it would de facto become a structure accessory.
Correct.
First. And I think did you review the definition of a structure accessory? Because I think that's less vague.
The plans were submitted within the written and established ordinances of the village about what I was building and what was required to be permitted by a licensed landscape contractor. The work that I permitted, or the work that I submitted, was not prohibited. There was nothing I was trying to push for to seek a variance. It was all within the village ordinance or code. And it was approved. And the work was more than 70% substantially completed when the village came out and tried to stop the work.
I appreciate the frustration. I really do. I think. Like, for us, like, our role here as a Board of Appeals is to grant requests for variances and to interpret. You know, the code to see if it was misapplied. It doesn't sound like that's what you're asking for from us. And we can't. We can't make a decision based off of.
I don't necessarily understand what you're saying, because basically what is being objected to is something that there isn't even agreement on based on the language and the ordinance of the code in the room. There's a definition for something, there's not a definition against something. So that's exactly what I'm asking.
Yeah, but we're not the people that you would come to for that specific issue. We are here to interpret the code and we're here to interpret and to grant requests for variances. That's all we can do.
Okay, but I'm still giving you the factual statements of the situation that we're in. So if I'm here in front of you for some reason and I'm not supposed to be in front of you, then I don't necessarily understand why I'm here.
Can I ask a question that might help?
Yeah,
Are you asserting that the inspector was right the first time
no,
when he approved it?
I'm not making any.
Oh, okay. Because that would be, I heard you say that the trellis complies with the existing code. And I think what they're trying to understand your argument.
The trellis does for what a trellis is in definition, and Inspector Burris, I beg to differ. Within the code someplace, there are mentions of what constitutes a trellis or an arbor and what doesn't.
There are not.
There's a situation, that's the issue.
And if I may, so specifically,
We do a church.
my understanding is that, so a notice of correction was generated. And what is being appealed is that order, that notice of correction. In that notice of correction, it says pursuant to Village Code 2258B5, the height of the trellis structures on the south property line shall be limited to a height no greater than 4 feet. And then it, again, details the articles of offense, that no fence more than 4 feet in height may be erected between adjoining properties, and gives the definition of a fence. So again, the village's position is that these are fence sections. We made an error in approving the permit as trellis sections, and that the appeal would be that of this notice of correction to amend the height.
Okay, and I believe that this has been stated by the applicant, but you are disagreeing that these are fence panels.
Correct.
Any further state?
Based on the ordinance as such, based on the ordinance as defined by the village. It is absolutely potentially vague. And I totally disagree with that these are fence panels, because they would not constitute a fence in any other situation. It's not keeping my dog out of their yard. It's not, it wouldn't be acceptable if I had a pool. It does none of those things. It's 3 freestanding structures that are trellises.
Okay.
So,
Any further questions for the applicant? Hearing none. Thank you.
Yep.
We appreciate your testimony. You can have a seat.
thank you.
At this time, I'll ask if there are any other members of the public that would like to make a statement on record relating to this request. Please approach the microphone. You can introduce yourself by name, and before you give testimony, our clerk will swear you in.
Can you raise your right hand, please? Thank you. Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Please
And-
state your name.
Oh, thank you.
Yep, sorry.
State your name again.
Suzanne Picarelli.
Picarelli.
I'm not gonna even attempt to get into the semantics of this arrangement. I will point out that the panel / fence / trellis / whatever it is are directly under our eaves. they would be extraordinary burglar ladders, permanently installed burglar ladders. I would also point out that they are constructed of the same materials as all the fencing on the property. They are 6x6 posts, which certainly is sufficient enough to hold up anybody that would care to climb them. And a 6x6 post is usually employed when you want to build a 2-story deck. I will leave it at that.
And for clarification, Ms. Picarelli, are you an owner or occupant of the home directly adjoining this property?
We are the owners directly adjoining this property. The posts are on the lot line, so we have 6 to 8 inches of concrete in a very deep hole on our property. I'm now concerned about what kind of damage can be done by removing or by adding more large deep holes and filling them with concrete. The house is 103 years old. I think Charles Valentine would be a little concerned about how things are gonna hold up. Thank you.
Before you leave, do members of the board have questions for Ms. Picarelli?
And the letter that we received
Oh, yes.
today is,
Yeah, so we've received supplemental materials, appears to brought via email. Can you confirm that either owners or occupants of your property submitted those materials?
That's correct.
Okay, and those will be entered into the record. Michael, do you have any additional questions?
Yeah.
Thank you. Thank you. You can have a seat.
Thank you.
Okay. Are we prepared to enter into discussion amongst the board? Okay. In order to open up discussion, may we have a motion for consideration? And again, we're not voting on this right now. We're just entering into a discussion period. And this may be challenging to phrase in our public.
Let you know.
I'll try. I'm going back to the let's see, how do we want to phrase this? Okay. This is an attempt to create motion that we can discuss without attempting to indicate which way I lean at all. I move that the appeal of the interpretation of Village Code 225-8 B sub 5 as presented in the notice of correction of the village dated, I think, October 2nd, 2023 by the Village of Shorewood. Now I've lost. Which would allow the installation of 3 trellis sections at residential property 4039 North Richland Court, but not to exceed a height of 4 feet. That's this is really hard to phrase. Let's see.
Ultimately, what do you want it to do?
Yeah. Maybe if I phrased it just, let's see. As, let me try this without putting.
Well, could we consider it both? Like, could we do two, like, regions one as interpretation of,
Or just an appeal of the Village of Charlottes's notice of correction
Um,
to deny the appeal of the,
e-
because that notice gave options, as I understood it.
yeah.
well, this notice,
It is, well,
it's,
effectively did, let's put it that.
I mean, this just, the notice of corrections on October 2nd does not refer to the code provisions relating to accessory structures. Does it?
No, it doesn't.
does not, but if. Yeah,
So the notice of correction is stating that the structures may not remain in their current location at their current height. So they certainly, if the homeowner said, okay, I will move them back to comply with the setback, it would satisfy the notice of correction.
Mm-hmm.
Did you want me to read it back? Maybe.
I think it's still a work in progress.
Okay.
I mean, do we want to, like Kara suggested, approach this as a request for interpretation to allow? And separately, a request for variance,
I have no problem with doing the.
bifurcating?
To get, so that we don't have to come back to it.
Yeah, okay. So do we want to then, is there anything stopping us from beginning with the
Straight
interpretation
offense as.
Yes.
Set forth in.
in the notice of corrections? And then get us into hearing mode and discuss?
I think it makes sense to, if you're gonna treat it both ways, you can take a motion to either grant or deny the appeal of the interpretation. Even if that's denied, you can evaluate it as a request for a variance as well. Because the application actually fills out all of the sections.
Yeah, it's like a hybrid.
It
And
reads, it reads sort of like a variance request because
And there are no arguments on facts that come forth.
and then, the arguments that were made that, well, the village changed course mid-route, then you might consider that as part of the hardship.
Sure. Keep.
Why wouldn't I?
So to bifurcate it then, again, I'm thinking out loud. Deny the appeal of the interpretation of the structures as being a fence. I mean, that's the short version. You can throw in some.
But you don't have to get that specific either. Or
The interpretation.
you could, just deny or grant.
so is the granting, sorry, we're getting into the nitty-gritty details of this, but is the granting to uphold the village's interpretation? Or what is the
No, I think
granting of?
If you said, I agree with the interpretation of the applicant. You could say, I make a motion to grant the appeal and find that the interpretation or the application of 535-26 was improper and
And the fence
allow it to.
the structure can stay.
Yeah, right, yeah, you could, but if you think that that's not the issue and that really it's the variance issue, then then you deny and then move on to your discussion of the variance request.
Okay, so how can we move forward?
Yeah.
Take two motions,
Okay, so do we want to phrase it as two separate motions?
I think you can. I mean, in the way I read it, like you said, it might be considered a hybrid part of application, it might be challenging both the interpretation and saying as the backup, there, I meet the criteria for a variance.
Okay, so, the first motion would be to, and I'm phrasing it as, deny the appeal of the interpretation of the village of Sherwood as set forth in the
Notice of correction.
notice of correction on October 2nd, 2023. Related to the property at 4039 North Richland Court.
Or it could just be deny the appeal, alleging that the code was misapplied by the inspector's office. If that's what you, yeah, I don't think it has to be that specific.
Oh, okay.
It's not, I mean,
Let's go with that.
Let's go with the simplest version.
So
If-
if that's what it is, it's a motion to deny the interpretation of the village.
The appeal of
challenge
The
challenging the village.
the village inspector's office interpretation of the code.
So a motion to deny the appeal challenging the interpretation of the village code
By the inspector's office.
by the inspector's office as relating to property located at
4030.
4039 North Richland Court. I make that motion.
I said,
There's a second. Okay. And then secondary to that, we have a second motion.
Yeah, the second motion would be to, for discussion purposes, to deny the request for a variance at 4039 North Richland Court to permit the placement of 8-foot trellis structures on the property line, on the southern or northern, I forget which.
Believe it.
would it be easier to grant a to say, to have it, to move to grant a variance? No, I mean, to grant the variance and let the structures remain unaltered.
I suppose that would, yeah,
I think that's,
more direct. Without defining or.
yeah.
Boya, do you have those?
Kind of. So Michael Paulson, are you moving to grant the request of a variance of Village Code 225-B, 225-8B parent 5 to allow
Yeah, to allow structures.
the 8-foot structure?
Yeah,
Thank you. To allow.
Yeah,
you got it.
we got it.
Yeah, I'll second that motion for the purpose of opening debate amongst the board.
Right.
Okay, so our first was a motion to deny, second is a motion to grant. Okay, with that, let's open discussion of the first item, which is the motion to deny the appeal challenging the interpretation by the village. So per the notice of corrections, this is an interpretation that this is a fence. With some alternatives if the structures are moved, and perhaps we can remind ourselves of the definition of a fence, which the village has helpfully provided. This is at section 326-1A. A barrier enclosing or bordering a field, yard, etc., usually made of posts and wood, used to prevent entrance, to confine, or to mark a boundary. Commentary on whether these trellis panels, provided that trellises does not appear to be defined by the village code, meet the definition of a fence.
My reaction is that if you want to apply the code literally, these panels do not constitute a fence. Having said that, the fact that the applicant characterizes them as a trellis, both in the appeal and in the initial application for a permit, is really irrelevant because trellis is not defined in the village code. And if it is not a fence, then by definition, within the meaning of our village code, it is a structure. A structure must be at least in this side lot setting 3 feet back from the lot line and have no, and then it has certain height restrictions, but height restrictions don't matter in this case. But the setback from the lot line would apply. Now, I think what the staff was doing was trying to give the applicant a way out by labeling it a fence, and I think that was and I'm afraid if by setting up that dichotomy, I've actually made things even worse for the applicant because I have then forced it into a definition of structure and would force it at least to be moved that 3 feet. And I don't really necessarily intend or find that that's a necessary result, because within the spirit of the village code is, I accept Inspector Burris's thing. He's trying to meet the spirit of the code, which would be a 4-foot barrier, solid barrier is permitted. And that would be the least disruptive to the applicant and potentially to the neighbors. And I'm not expressing any opinion on footings or what that might or might not have. That's a separate issue and it's not before us. So I've talked myself into a circle. And I'm not quite sure how I can get back out of it, because I think what the village was trying to accomplish once they realized that an error had been made. The fact that an error had been made, to me, is irrelevant to the application of the code. Mistakes happen, and legally, at least for purposes of applying the code in matters before the board that we have jurisdiction over, the fact that a mistake was made is irrelevant. And I know how frustrating that is to the applicant. So I'm trying to figure out, having thought my way around that circle, is there a way I can get back out of it? Because I think a reasonable result is a 4-foot, these panels, that's 4-foot fences, but
Arguably, we haven't gotten direct testimony from the applicant, but part of the purpose of the trellis is for things to grow onto the trellis. So a 4-foot trellis, you know, I'm not sure if it would meet the purpose of the structure, but I agree that, you know, looking at the definition of a fence, although this does border a yard to some degree, it does not appear to be used to prevent entrance, not ignoring the gate structure, to confine or to mark a boundary. In which case we get ourselves into accessory structure zone. Kara, do you have any thoughts on whether these panels meet the code definition of a fence?
I mean, I could argue myself into thinking that it could be marked a boundary, but I just really think that the definition here is irrelevant. I think we get the accessory structure either, like, either way. You know, the applicant is very adamant that this is not a fence. That's fine, it's accessory structure, and here we go. You know, we still end up in the same place.
I think that's correct. and my circle is broken, so to speak, it could be broken. I'm not saying it will be. Could be broken that if this is a structure, then but the second motion of request for variance, you could break that somewhat circular definitional approach by saying that a variance is granted to construct a structure of these 3 panels not to exceed 4 feet, because we can put limitations on
Well,
the
the
grant of a variance.
variance for a structure would be the setback. Not the,
Well, well,
because.
Yeah, it could be up to 15 feet.
Yeah, we don't.
no.
But it cannot
yeah,
be within the setback.
Yeah,
side setback.
that could be within the setback, conditioned on the structure not exceeding 4 feet.
Yeah, there.
I mean, because, correct me if I'm wrong. We can put conditions on the grant of variance.
You can, absolutely, you can, yeah.
So, I mean, that would be one way of essentially, bottom line, affirming what the village staff said.
Yeah.
Because I think they were in the spirit of the village code, trying to come up with a permissible outcome that is entirely consistent with the code of, that is 4-foot height limitation on the property line.
But I think whether you put that in the motion or not, as I understand it, that's already on the table, right? I mean, that was.
Well, yeah, I know.
a Suggestion.
But
Okay. So would we like to open consideration of the elements required to satisfy a request for variance?
we can,
Do we need to finish the first one?
Well,
Was there a second on that?
Mhm.
yeah, there was.
There was a
I would-
second.
Yeah, if you've got a motion on the table, you should.
Yeah. let's finish.
No, we should finish.
Okay.
I guess if we approve, if we, so the motion was to deny an appeal. So if we do not deny the appeal, then we would be considering a variance for a structure. Is that right?
The second part of it is moved if you agree with the applicant that the code was misapplied and everything can stay as is, then there's no point in discussing the variance. But
Okay,
if it's denied on the interpretation issue, then you move on to
the variance,
the
okay.
hardship, unreasonable burden, and lack of harm.
So getting stuck on whether we deny the challenge to the interpretation.
Mhm.
When if we disagree with the village's interpretation as to it being a fence.
Well, I think that's irrelevant. I think the question is whether or not you agree with the argument that was made by the applicant. I mean, unless you want to fashion something, I mean, you can do that too. I mean, as you mentioned,
Well, that gets into the,
but
yeah,
because the Board of Appeals has the power under the ordinance to, let's see exactly which here.
no, I'm not worried about the conditions on the variance. I'm worried about the first part.
Yeah, yeah.
But yeah, I mean, you can. Says that. You can amend it in any of your orders, you can change it pursuant to how you apply or interpret the code.
So perhaps, are we in agreement that, well, I don't. I'm getting myself into a predicament here, because if I disagree with the interpretation that this is a fence, does the board have the authority then to say, if this is not a fence, it falls into the category of an accessory structure?
I don't think you have to go that far. I think you can say the applicant has advanced the argument that essentially the village got it right the first time when it approved when it first approves the permit, and that it correctly interpreted the code, that what I built
Was not offensive.
is, well, regardless of what you call it, that it was in compliance with the code. Do you buy that argument or not? That's the only thing you have to consider. If you don't, you can deny the appeal and reject that interpretation of the code. I mean, however you want to word it. Or if you say, oh, we agree, alternatively, we agree, we think that the village got it right the first time when it issued the permit. And it correctly interpreted the code when it granted the permit, and we think the mistake was made by reassessing that, then you just grant the appeal and we're done. But I don't think, I mean, I think that's all you have to do is say, do I buy the appellant's argument that the code was properly applied the first time? I mean, that was the argument that was made. Yeah. I think that was the argument that was made, right?
Yeah.
So does that require,
Ask me to speak.
We may have to rephrase,
yeah,
I don't know how I withdraw a motion that's been made and seconded. Or substitute.
Is there unanimous, if there's unanimous consent, you can do that.
I consent to Mike withdrawing his motion and rephrasing.
Right. And so now I've forgotten the way you phrased it, Nate, but I think it is, to grant the appeal,
No, it would be to deny
deny the appeal.
the appeal of the appellant's deny the appellant's interpretation of the code. And reject. It
You had
would be deny. The appeal based on the allegation that the village misinterpreted or misapplied, that's it. Deny the appeal alleging that the village misapplied the code. I think that does it. And then you consider the variance.
I'll accept that phrasing.
So the motion is, and again, I don't care whether it gets passed or denied.
Right. We're just trying to get a,
And I don't care what the vote is. I do not vote. I don't care. I'm just, from what I hear you saying, I think it's either I move to deny the appeal alleging that the village misapplied the code. What do you
in
want?
granting the permit.
No, I don't. I think that's it. I think that's enough.
Period.
Yeah, I think that's enough.
For a point of clarification, Toya, was that first motion, I believe I may have made it.
You did.
Okay, in which case, is there unanimous consent that I withdraw that motion? And in its replacement, I move to deny the appeal brought by our appellant alleging that the village misapplied the village code as relating to the subject property.
One more time, please.
I move to deny the appeal brought by our appellant alleging that the village misapplied the village code as relating to the subject property.
Misapplied.
Yes. And is there a second?
I second.
Thank you.
Relating to the,
Subject property.
thank you. Seconded by Carr.
Yes.
It's far better than getting into my circular.
It's difficult, and we're trying to get it right.
Are there further discussions that need to take place, or are we ready to proceed to a vote? Okay. Toya, can you call a vote?
Yes. Wendy Smith,
I vote to deny the appeal as moved.
Michael Paulson,
I move to deny the appeal as moved. Because I'm not sure whether or not or
Cara Espera.
I would deny the appeal as well.
Motion carried 3-0.
Okay, with that, we're not done. Our second consideration here is whether this request meets the criteria for a variance. And there are elements demonstrated within the applicant's materials suggesting some argument on the criteria for a variance. Opening,
Yeah, do we have the motion on the? Roll that second one?
Michael, you moved to grant the request of a variance.
that being said, discussions about whether applicant's materials or testimony satisfy the criteria here for a variance, which would be request for the trellis to remain in their places within the 3-foot setback at its current height. And here we're looking for those extraordinary or special circumstances that would support granting a variance.
Excuse me, can you clarify, you said accepting it at the setback with its current height?
Yeah, so here we're considering whether the applicant should be given special permission to allow these panels to remain in place on the lot line. If our interpretation here is that as an accessory structure, this wouldn't be permissible within 3 feet of the property line. If we're considering a variance, we're considering whether special permission should be granted to allow them to stay, essentially, and not be moved further back from the lot line. And here we're looking for these special considerations relating to the property itself that would justify our finding of, the need for a variance.
And
Well, we are in our hearing.
yeah, the facts have changed.
Yeah, we are relying on your application materials.
Everything that's in your application, all your arguments there apply equally as well to this.
Hardship that would be something that would not affect you addressed.
You have a.
I believe there is a statement.
Materiality, denying, that's a
Yeah, right.
choice of materials.
Yeah,
4-foot posts. And restructuring.
yeah, all that's all in there. Yeah.
Thank you.
For one, I mean, jumping to the second element of our variance criteria is looking for an absence of detriment. And here we do have testimony and material from the neighboring property objecting to the placement of these panels. In other circumstances where requests for variance have been presented to the board, where there is no objection from neighbors, we have looked at those considerations. But here, it appears that we have some complaint about the placement of the panels.
Maybe it might be helpful if we just go over the elements to grant a variance for audience, which I do not have memorized.
And I,
At least not.
so yeah, they're in 535-58 in the code. And if you look at the nice thing about the Board of Appeals variance application is they go down 1, 2, 3, and they match the ordinance. So if you look at the application, he addresses them all in order. The first one's hardship, and then unreasonable burden unique to property, and then just the granted variance or lack. So it's 535-58, and so it says no variance shall be granted by the board unless it finds all the following facts and conditions exist and indicates in the minutes. One is an exceptional circumstance. It says there must be exceptional, extraordinary, and unusual circumstances or conditions applying to the lot, parcel, or structure that do not apply generally to other properties in the same district. And the granting of the variance would not be of so general or recurring nature as to suggest that the chapter should be changed. In other words, the exception should not swallow the rule. Then absence of detriment, the variance will not create a substantial detriment to adjacent property and will not materially impair or be contrary to the purpose and spirit of the chapter. Again, it shouldn't, the exception should not swallow the rule. And so the other items that are listed in the appeal application are some of the other considerations that are listed in 535. 55, where it says that, that this body has the power to grant appeals and variances as will not be contrary to the public interest. Where only to special conditions, literal enforcement of the code would result in that practical difficulty or unnecessary hardship. So again, that's where those come from.
While I understand the difficulty of having a permit approved in error, as we've discussed previously, that's not as relevant for our role in interpreting whether this meets the criteria of the variance. So looking at applicants' written materials relating to the criteria for variance, I don't find that there is exceptional, extraordinary, or unusual circumstances about the law itself that would justify placement of this type of structure within the side setback. There is commentary that, the adjacent property has a house that is very close to the edge of the lot line, but that is the case with many houses in the village. And as Inspector Burris has stated, this is legal non-conforming. So I don't find that to be convincing in terms of special circumstances relating to the property itself.
I tend to agree. I think the changes that were made, like the post constructed, they're very aesthetically pleasing. They look nice. But, compared to the concerns of the neighbors' safety, I think that kind of outweighs in my mind the harm that could be done versus the trellis in this situation would not be enough for me to grant the variance.
Yeah, I tend to agree that there is nothing related to the specific lot that creates a necessity, if you will, for an 8-foot structure panels within the setback. The legal standard for us to grant a variance is very strict. It's very difficult to meet. We have on occasion granted them, but it's when there is a colorable argument that a hardship would be imposed upon the applicant if a variance were not granted. And I see no hardship that the applicant would be faced with if there were no variance given. Sorry about my semantics and my grammar. I can understand the applicant's frustration with having gotten a permit, thinking everything was going forward, and then having village change its interpretation and application. But legally, under the law, it's my understanding that a mistake by the village or the permitting authority is not a basis on which to find a hardship. And we have to find hardship in order to grant a variance. I am aware, if my memory of the case law is correct, of, in fact, applicants being forced when a variance was denied to literally move the foundation in order to comply with the setback requirements, which is far more substantial on a financially and otherwise than in this case the moving of these panels. So I concur that under the legal standards by which we can act, that the grant of a variance would not be appropriate.
Further discussion on the point of variance request? Are we ready to proceed to a vote? Toya, can you call the vote on the motion for the variance?
Michael Polson,
Should we,
I'm sorry, Michael, so the motion was Michael Polson moved to grant the request of a variance of Village Code 225-8B parent 5 to allow the 8-foot trellis structure to remain unaltered. And it was seconded by Wendy Smith.
and this was a motion to grant.
So I vote against the motion
Nay,
to deny.
okay, Michael, Cara Espera,
Okay.
Wendy Smith,
Nay.
motion failed, 3-0.
All right, to summarize what we've done here is that we've denied,
Mhm.
Toya, you should maybe better. We have denied, a appeal by the applicant alleging that the village misinterpreted the code. We have effectively denied a request for a variance. Okay, so results of that voting will be distributed by the village to the applicant, correct?
Correct, yep,
Okay.
and I will note that it will state thereby denying the request.
Michael, do you have a comment? Did I misphrase?
Oh, excuse me.
No. I'm wondering where that leaves the parties.
Well,
Or is that not our concern? Is, I mean, I have no problem with correctly applying the law to the facts. Do we need to go beyond that to clarify anything, or is that up to the parties in the village inspector to work that out?
I think you'll follow up with.
It's fine, right?
Yes.
Sorry. I didn't mean to-
additional direction
Another
shall be forthcoming from the village. With
There-
that,
There was, mentioning that if they want mediation, the village would provide it.
okay,
But I don't know if you want to go on record and stuff. What
Um,
Rebecca said.
I am not aware of that.
No, that came from the village manager.
I didn't.
The point of mediation, is that something we need to get into?
Not by us, not by, yeah,
Okay.
okay.
Returning back to our agenda, having no other items on our agenda, this meeting is adjourned. Thank you.
6:57. Just one moment, just you could just hold just one moment. I need to formally stop the recording.